We talk more about technology transfer. So last week we have discussed some very basic elements from high technology law, technology transfer law, and some like science and technology laws. But in this lecture, we focus more on technology transfer with more contents and concept, process, and even like the the key like the key contents of just technology transfer in university, and why we have to talk about the technology transfer in universities, because we can see it later. So of course the need for technology transfer start from long time ago. It's not only like we when we have technology transfer law in Vietnam by 2017, amended by like a law on technology transfer in 2006. We can complete like we can develop the market, but like a long time ago we still have that is like a very basic need for any economy and countries. So as like again, why we have to build law, to issue laws, because we want to manage activities in the economy, in the society. So it's not like we have to have law first and then we have actions, we have activities, but we have some actions, activities and requirement from the society, and to make the activities transaction more transparent, more efficient. So that's why each government have to develop laws. And as you can see here, if even like before 1988, we have technology transfer. So go back to the like Vietnam War time. So still like we were learning from other countries about the like the army technologies. So that is like one kind of technology transfer. Of course, for each specific period, we have a specific technology transfer reason and procedure, but it's like it's very basic activities for every country. So the first legend wrote like a document in Vietnam about technology transfer is ordinance on the technology transfer from foreign technologies only. We did not focus on like internal or domestic technology transfer. So whenever we talk about the technology transfer, we talk about the technology transfer from other countries to Vietnam. And why we did not consider technology transfer inside Vietnam? Because at that period, so the government manage almost all sectors. So that means every like a pattern and every the owner of every technology development belongs to the government. So that's why it's not officially we consider or we pay attention on domestic technology transfer. But of course, because of the development of the lawmakers and also like the development of the whole society, the definition of technology transfer at that time is not really like clear and developed enough as compared to what we have now. So at that time, the concept of technology transfer just like the sale and purchase of license. So we just talk about the license when we buy a technology. And after that, like until after like nearly 20 years, we develop that to the to the law, the first law on technology transfer in 2006, and later on amended in the law on technology transfer in 2017. And at that time, technology transfer means the transfer of the right to own and the right to use. So we separate the right to own and the right to use a technology from the party that has the right to transfer the technology to a technology transferee. And you can see here, it's really like advanced definitions here, because we separate the right to own and the right to use, and the party who has the right to transfer. So sometimes the owner of the technology do not they do not have the right to transfer. So it's quite complicated. So that's why we have to update, we have to amend the law to follow the complexity of the technology transfer, because technology itself is complex. So that's why we have to develop the law to catch up, to adapt with the complexity of the technology and technology transfer. And as we already know, so after the technology transfer law in 2017 issued, so the technology transfer market of Vietnam has developed very fast from that moment, because now own partners have more confidence to do technology transfer. They know what to do, they know how to do, and also we encourage the development, the faster development of new technology. And with the introduction of this law, so all regulation of technology transfer has been made mandatory from the 1st July 2018. And we say that, okay, now from that time, all technology transfer have to be regulated. So technology transfer is not an action, it's a process. So for each technology transfer project or process, it involves different stakeholder perspective, and because we have developers, we have users, we have the traders, because of course, as in other market, sellers and buyers, they do not they cannot have a direct meeting all the time. So always between developers and users, there are some traders. Traders can be individuals or organizations. They have knowledge about the market, they know about the technology, and they know how to connect developers or buyers to users, or no, developers as seller, and users by buyers. So each stakeholder in this process, they have a different perspective. For example, For developers or sellers, they expect to sell or to transfer the technology, new technologies at a high price, and sometimes they have perspective to separate the technologies as much as it can. Like they want to more users for their technology. So each technology transfer will operate and can be understood at different levels, because sometimes technology is ready to be transferred, and sometimes and that is like a very complex technology, but sometimes it can be like developed at a certain level of development. So that's why they will have like a different approach for each type of technology and each development level of technology. And then like the seller can be an organization or an individual. So for each type of stakeholder, we will have different process and different phases we have to do. So we can say like that is like a communication process. So own like a communication process or own procedures are well defined in the law, and then we will take a look later. There are two main types of technology transfer in Vietnam. So technology transfer from a foreign country to Vietnam, and technology transfer from Vietnam to other countries, and domestic transfer in Vietnam. And then accept, like, of course, we can classify all technology transfer type in this three types, like we see now in slide. But of course, there are some like some restricted technology transfer that like require specific permits. Why? Because as we discussed last week, there's some like some specific technologies related to national defense, for example, or very like toxic applications. So it needs very specific permits or like uh, approve from the government to do such kind of technology transfer. But basically, from our like point of view, like we just do the normal technology transfer from university, for example, or from research institute to other companies inside or outside Vietnam. We focus on like three types of technology transfer as we are now seeing. Also for technology, we have to like remind again, is a solution or process or know-how that may or may not to be supported by instruments and facilities to convert resource into products. And on when we talk about the technology transfer, we have to define, okay, that is a technology or not, because not like a product, physical product is easy to evaluate, to even to catch, to touch. But technology sometimes is not the one we can have a very physical assessment like that. So we have to find out that like the object we are talking about is a technology or not, because when we want to do technology transfer, that means we have to own or we have to write to transfer a technology. That should be a technology first, and then we can do technology transfer. So the technology transfer is the transfer of the right to own or to use. And remember, that can be a part or whole technology. From a party, we have the right to transfer. So here we have to see the highlight here, like own or use, the first one, and a part or whole. Sometimes we do technology transfer, but not for the whole technology. We can separate in several parts, and we can transfer each part. It depends on the need of buyers and the development of the technology itself. For example, there are 3 stages for one technology, one whole or complete technology, but we develop step by step, and then we can transfer like a part of them. It's not necessary to transfer all technology, whole technology. And really important, why often we talk about the technology transfer and the IP right protection, because in case the technology transfer involves IP right protection, so we have to also consider the content of the law on IP, and all like partners or stakeholders need to register for IP right and technology transfer separately. Because you can see like we transfer the right to own and to use, but the IP right protection is different stories. But when we have a right to use a technology, it doesn't mean that we have IP right protection. So that is like a separate stories. Okay, so as you have some time to read this one, so type of technology
Cho không ném
transfer.
lửa pít nhá, là ra là nó fire cái góc tao đứng trên lầu luôn. Đi mẹ sao luôn được. Có thằng đi ranker ấy. Mấy điển đi mẹ kể cả thế.
So classified by Technology Transfer Law 2017. So there are 3 types of technology to transfer, like encourage, one, restricted and prohibited technologies. So for the first type, that is like relevant to the level of advanced technology, clean technologies, green technologies, and renewable technologies, or like in energy sector, we can see like new and renewable energies or storage energies, efficient, like more efficient energies, and also like related to the medicine diagnosis and treatment, protection of the human health, and improve the significant strength of Vietnamese people. Like we can say like a good technology for human being and for the society. So that is like we encourage to transfer kind of material technologies, either domestic transfer or foreign transfer. And when we talk about like, okay, when the government wants to encourage technology transfer in a specific sectors, so that means they will give more incentives to stakeholders for doing so. For example, in the new law on investment 2020, so project involving transfer of technologies like green technologies, like so they can enjoy investment incentives. So it can be like income tax, it can be like import tax, it can be like land rental fee or some other tax assumptions. And even like they can get low interest loan from banks. So that's some very particular support from the government to encourage the technology transfer in green sectors. Vice, there are some other technologies and not like very welcome for technology transfer. So technology no longer popular or considered quite like dangerous to the environment, and but like still acceptable range under the national technical standard of Vietnam. So back to this one, we can see, of course, when we do technology transfer from a foreign country to Vietnam, so that technology can exist in that country for a long time, but not in Vietnam. Of course, for us it's new, but for the domestic country itself, that technology is quite out of date and no longer popular as defined in the law. Of course, it's still like meet our standard, technical standard of Vietnam, but it's out of date already. So we are not encouraging to do such kind of technology transfer because we expect to have newer, modern technologies to catch up with the international level of technical standard. So of course, we still like allow for technology transfer implemented for that technology, but it's not really like easy as the green technology transfer. And in that case, the transfer or biosellers as all stakeholders have to explain very clearly why still we need to do that technology transfer, because we need that technology and we have to propose the solution to use efficiently that technology. And give some solutions to limit, to reduce the damage that technology can cause when it is implemented in Vietnam. And sometimes we have to increase our national technical standard to make sure that all technologies transferred from a foreign country to Vietnam have a high quality, efficient, and update technologies. And because this technology transfer can cause damage to the society, so there are many legal documents issued by the ministries, issued by the government to regulate this kind of technology transfer. So of course, in practice, in Vietnam, by law, and also there are no specific international treaties that Vietnam is a member. They described in detail technologies restricted to transfer, and so that's why, in order to decide whether certain technology to be transferred, we have to understand the nature, the function, and the byproduct of such technologies. So that means for the technology transfer request or regulation, we have to investigate the document. We have to find out the nature of that technology, own contents, and own consequence of the use of that technology. So it's quite complex process, and then it takes time to do so. So to be facilitate the process, each regulators have to submit the complete document about the technology, and to prove and to explain the damage may caused by that technology, and have to prove that the technology meet the national technical standard, at least by the time they submit the document. And so responsible parties for a technology transfer in Vietnam. And remember that even for technology transfer from foreign country to Vietnam or vice versa from Vietnam to other countries, so the Vietnamese party is only responsible for the registration process. And that means for one technology transfer, there are foreign parties and Vietnamese party, but the Vietnamese party have to be responsible for for own registration process in Vietnam. So in case we have technology transfer from a foreign country to Vietnam, so the Vietnamese party is transfer free. And when we do transfer technology transfer from Vietnam to a foreign country, so the Vietnamese partner should be transferred. And we have to know when we want to do a technology transfer, so which government unit we have authority we have to ask for. So in case of a domestic technology transfer, so the principal department at the province can be the authority, the government authority. You can ask for, you can come and do own process. But in case you want to do technology transfer between Vietnam and a foreign country, we have to go to the Ministry of Science and Technology most. So it depends on the level of technology transfer, international or domestic technology transfer. We will have different authorities that we have to work with. Always we have a fee for one one technology transfer registered. So to estimate the technology transfer agreement, the government has set the fee equivalent to 0.1% of the total value of the agreement. So of course we have the limit, upper limit and lower limit for the fee. And remember that for fee, it can change from time to time. For example, that fee is defined by law, not often in law, because for fee it changes quite fast. So it's is it by the under law document only, and it change. For example, they can correct, they can adjust each year. So whenever we do technology transfer, we have to verify again the fee, the current fee for the technology transfer agreement. So he give you some ideas how they evaluate how they take fee for your agreement. For example, often it's a certain percentage of the total value of the agreement, and there are upper and lower limit for that fee. Here is some mandatory contents of a technology transfer agreement. So very important. The first one is the name of the technology to be transferred, and technology transfer itself and product created by the transferred technology and the quality standard, and that will provide will have the government like the government authority to evaluate that technology is the technology encouraged or restricted to be transferred, and the transfer of the ownership or and the right to use technology. So we have in this agreement, we have to clarify we will transfer the ownership or the right to use only. And we have to mention about the method of the technology transfer, because each type of technology we have different method to transfer. Because if we have technologies in energy sector or in biotechnologies or in agriculture or in chemical and industry, so they are like quite different technology transfer approach, and also it depends on we transfer ownership or the right to use, or we transfer all of them like ownership and right to use. So we have to mention about the method. So we will have training, we will have like we will give own technology documents to be used or duplicate in a new place, or we just to transfer the right to use with a product or machine complete, and right and obligations of the parties in that agreement. So each party have their own right and obligations to implement. So what would they have to do, and what they have right to use or to develop or to own, and price and method of payment. The duration and effective date of the technology transfer agreement. So it can take like a month or year to complete the technology transfer. So the technology transfer agreement have to mention clearly like which date is like the technology transfer agreement will be effective, and the duration that technology transfer agreement valid, because sometimes they will transfer the right to use technology in a certain time. It can be a month, it can be years, but it should be or like unlimited time. So it really depends on the nature of the technology and the specific request from each parties in the agreement. Definitions and terms used in the technology transfer agreement. So you can see here in each row, always at the beginning, we have to list the definitions and terms used in the law. So the same in this technology transfer agreement. So we have to define, we have to give, to present very clearly definitions and terms used, because for each term and used, so they can be understood with different meaning. So that's why we have to, for always for legend documents, they have to give very specific definitions that they use in the legend document, because otherwise after sometimes there are some conflicts between parties because of different understanding of the terms used in the agreement. Technology transfer plan, schedule, or location, yeah, and guarantee of transferred technology. Of course, it's not like, okay, like when we sell a technology or product, we have to give some time for warranty of our product. So when the technology transfer agreement signed, so involved parties need to submit their registration application to the relevant government authority within 90 days, like 3 months of the government of the agreement signing date. And there's a list of documents they have to provide. And you can see the, okay, if like we have to do international technology transfer, so all technology document and technology transfer agreement have to be translated in Vietnamese. We cannot submit like all documents in English. And also like we have to present investment registration certificate copies of both parties if like they are companies, or even for university, we university do not have investment registration certificate, but they have to present the registration certificate for like for technology transfer activities, like they have a right to do so. And then after submitting your document, we have to wait for like the government authority have to process, and processing time quite short, you know, 1 week, like 5 working days, like equal to 1 week. And the the competent authority has to issue the registration certificate or provide the reason why they reject the application. And in case the argument is incomplete, the government authority need to inform like applicant within 3 working days to amend or to provide supplement documents to complete the application. And of course, that is like the standard process, but sometimes with very complex technology, so the government authority may need more time to process the application. And in that particular case, so they will have to exchange with the applicant for to extend the time for processing. So above we were talking about the application about the registration for technology transfer in Vietnam, and we will move to the next content is technology transfer in university, and why we have to emphasize technology transfer in university. Because scientific researchers from university are the main source of the new invention to be patented and also to be commercialized. And university technology transfer is the process of promoting and encouraging the creation of new technology. So in a society, universities and research institutes the center of the new inventions and new technologies to be transferred. Because of its important role in the technology transfer. So the use, protection, and commercialization of the intellectual assets and IP knowledge, innovation management at university become the concern of both government and universities. So both government and university have to pay more attention on the technology transfer itself, and also like relevant and activities around like how to develop more new technologies, or how to even protect the innovation, and how to develop IP knowledge and innovation management for the staff at the universities. And the government have to also like encourage the innovation and collaborations activities between universities and the enterprise through technology transfer, as well as like consultations and training on IP and providing information and reasons. And as we know about like science and technology law, the government give funding for research activities because they want to develop, to encourage the innovation at universities. But now they also like not, if they only provide funds for for innovation, for research, but they do not like create another fund for collaboration activities between universities and enterprise through technology transfer. So that means they just pay attention at the first period of the whole process. So if all researchers and universities, they stop at the research stage, that means the outcome, the innovation at university never come into the society. So it means nothing. It doesn't make any sense to have funding for research without any application later. So that's why they will give more like more attention and guidance to promote technology transfer between universities and enterprise. So when we talk about the technology transfer in university, so that means we talk about the process of transferring scientific findings from university or research institutes to another for purpose of further development and commercialization, like from lab to commercial product in the market. And before going to another like content, so we will have a 10 minutes for a break. I have to take a screenshot. For those who cannot open your camera, so you have to send a message either to everybody or directly to me in the chat, and then I will like review it. And because we now all know that technology transfer in university plays an important role for like not only for the university but also for the whole society. And both government and university have to pay more attention on like promoting and increasing the knowledge and provide funding and create some like law or under law document to promote such kind of activity. And from the university itself, it should have like a technology transfer office. And so do you know at UTH we have such kind of office or relevant department for that activity? Any of you know? Okay, no problem. So at UTH we have as I remember correctly, so we have innovation department, science, science and technology and innovation, I think. So that office will promote research activity to connect the research activity between university and also to connect university with the enterprise, and they have to do both scientific promoting test and also regulation and law or and any legal process for the technology transfer and also research activities. Here and you can see some other functions of technology transfer office at the university. So for technology transfer office, they do not only promote the research and technology transfer between researchers and scientists with others, but also students, because students at higher level master or PhD levels, they also have their own research. They can have their own pattern. So they may need to need support from this office for technology transfer if their technology is mature enough. Why technology transfer in university? So better transfer and industrial linkage can open up interesting new lines of inquiry. So you can see if we can promote more technology transfer between university and industrial partners, we at first we can have increased funding for scientific research. So the income for both scientists themselves and their research will be higher. So more more attractive sector for newcomers, for young generation. They will the excellent young researchers. They will stay back at the university to work and to develop and to invent more. So the university can have a huge benefit, but also industrial partners, they can use the a new technology to improve the business activities, and also through discussions between academic and industrial partners, they can have more practical ideas, practical inquiry for new research. So the research topic for researchers, they will have they will update with a newest challenges in the industry to be solved, and that's why we can increase the mutual benefit for both partners. And also this kind of transfer and collaborations can expand opportunities for education. So education have more attention from industrial partners. That means we have more funding for education, for training programs, and also young students, they will have more opportunity to work for industrial partners, and it will be easier for them after the graduation, because with like existing experience with industrial partners, so it's easier for them to find a job later on. And also the in the last part, you can see like the link between university and industrial partners can build a national and regional competitiveness. Technology, new technology itself is very variable, but if they are just in the lab, in the research lab in university, on paper, even like very famous scientific papers, so it doesn't mean that the society, the people can use that technology. So we need a transformation process from technology to the final product to serve the society. So it's really important to promote or to encourage more transformation from technology to product, because more transformation from technology to product, so more technology, new technology will be invented, and the efficient, more we will have more efficient technology, more clean technology for our daily life, and for more efficient business activities. So from innovation, we will have to do disclose, and then of course during that process we have patenting agreement administration or licensing. So all administrative process like this, we will have like to do commercialization process, or even like a product. Push and pull forces initiate technology transfer. So here we have like a technology transformation and product. So product should be like a demand from new technology, and supply is like the source of new technology. So first of all, we talk about the demand first, and because whenever we invent something, because we have demand for that, so always in any market we talk about demand first, because supply production should be implemented because we have demand. So without any demand, we do not have supply. So demand first, here we have like a demand pull force. Why? Because in the industrial sector, always they need to improve efficient activities. They want to increase the productivity. They want to reduce energy consumption. They want to have like less human resource and less time to produce wood and products. So that's why they need like their huge demand for new technologies. So we say like a demand pull. Always they want to attract more new technology for activities for production. And supply. So supply is universities or R&D department or research institute. They have motivation to push. Here we say like a supply push, but they want to introduce, they want to give, they want to transfer the technology, new technology to other partners. Why? Because without any technology transfer, they do not have enough funding to continue the work. So that's why they also have push folks to give, to transfer, to apply the new technologies, and then they will go back to university, to research institute, to the lab, to invent more technology. So transformation or technology transfer have two types of forces: demand pull and supply push forces, to develop or to encourage the technology transfer, and that is the real need from the market. So that's why the government have to issue law and under law document to facilitate or to develop market for technology transfer. You can see here innovators or research scientists, they see like opportunity to profit from a new technology, but of course from users, they do not know that technology because the new technology always at the lab. So that's why technology push is like the technology must be presented, published for the society, for the people, and then when users, potential users, know that technology, so they have more opportunity to transfer the technology. Envivus market pool, that means existing firms or enterprise seek better technology to reduce the cost and a product or make the marginal improvement of the quality of their existing products. So the need exists, but there is no currently no technology to meet that need. And of course, for need of the product and need of the market increase or happen all the time. So new need, new requirement from the market happened all the time. So that's why they always need a new technology to meet that need. So here you can see entire technology transfer process from new technology to the final like a product commercialization. Here you can see like from idea, research idea and technology idea to a prototype, and then to the product, the final product. So there are few key things you should pay attention. The first one is like, okay, we often talk about the R&D department, but you see here there are two types of R&D. R&D stands for research and development, but R&D, technology R&D is different from technology product R&D. So technology R&D, that means we develop, we research on technology itself. We do not have a final product, final commercial product. But for product R&D, that means the researchers there, they focus on like applying a specific technology for some one or specific product to improve product, to finalize technology for a product. And then after this product R&D department, so that means we are successful to produce a good product, and then in next step we have product commercialization. That means we produce that good at larger scale, at commercial scale. So product R&D, that means they will produce or they will test, and then they will make sure the quality of the product at the lab. And technology R&D department, they will test, they will develop technology from ideas. They will finalize it in like complete technology, and they will make technology available for technology transfer and to transfer to the industrial process like a product and commercial product. Do you have any questions so far? Okay, one question is like, what does R&D stand for? So I just repeat in the lecture. So R&D stands for research and development. Yes, research and development. So often when we talk about the research, we think about university or research institute. And for development and for product development, we talk about we think about the enterprise. But now we have both R&D department in university and in industrial enterprise. Why? Because you can see here, we have two types of R&D. R&D, technology R&D. That means researchers here, they research on new technologies. They transform, they convert ideas, new ideas to technology, to complete technology and make technology available or complete for technology transfer. That means it's ready to be applied for industrial process. So that means we have like R&D, because if we only talk about research, that means, okay, we convert from idea to research paper. We have very nice scientific report, but it's not enough. It's not ready. So they have to develop that technology to make it available. That means it's ready to use technology for industrial process. And another type of R&D is product R&D. So product R&D department, often you can see them inside companies. So product producers, because they will do research on the product. They want to find out like how to improve the quality of product, how to decrease the time production, the human resource for production, and the energy for production. So that's why they have to do research on product, and they also like apply new technologies to improve the quality of product. That means develop, research and development. And two types of R&D, saying that the key object, technology or product. For example, when we talk about the iPhone, we say that is product, but technology we use to produce iPhone, functions we use, and on like own technology inside. So there are different things. So technology is used in one product, and product itself. And if you like now you are students, and maybe later on you will go further for master or for PhD, or you will go directly to the industrial enterprise. So you also can have like a work job at product R&D if you have very strong background on scientific knowledge. And why, when we talk about the technology transfer and right to use and to own, we have to talk about the intellectual property, IP, because we cannot like, okay, that is separate stories, but we cannot separate them. I mean, we always have to do it together, because to do technology transfer, we cannot ignore IP right protection. And why we have to define IP right protection? Because we have technology transfer, the right to use and the right to own. It seems to like IP and technology transfer, they exist parallelly. And IP refers to the creation of the mind, like inventions, literary and artistic works, simple names, image, design, and use in comics. And IP is protected by patent, copyright, trademarks, and trade secret. So we all know these terms already in the in the first lecture. And so whenever we before like doing technology transfer, we have to take a look at IP right protection. Do we have a right to do so? And also like, do we need to register IP right before doing technology transfer? And very often for each invention or for each like creative work, for each commercial value, things like symbols, logo, or names, or image, or designs, we have to register for IP protection. Otherwise, we will have trouble or we will lose our benefit when we do technology transfer. And do you know why, like scientists, of course, for each research idea and research paper is not enough to register for IP right protection. So all researchers and scientists, they have to publish their research results on like academic journals in the form of like a scientific article or paper. So that is also like recognized or agrees as an, how to say, in declaration of the work. And if they are the first one, that means the second one, the third one, like all other people around cannot publish the same thing, or they have to prove what difference is between their own research results to another one published already before the publication. So that is like a very basic activity that scientists have to do when they create something new. And firstly, they will publish as like a scientific article or paper. Of course, it's more complicated with the IP right protection in the commercial market or in industrial sector. But still, like we will have to make sure that okay, all invention or commercial works have to be protected by, like as you see here, patent or copyright or trademarks or trade secrets, or even like more form of protection. Firstly, we talk about patent. So what rights does a patent provide? So if you have patent, that means you have a right to exclude others from making, using, selling, or importing the patent invention from a limited time. And for example, why they have, okay, the first part, patent can help to promote the progress, the advantage, like advancement of science and useful art by securing for a limited time to authors and inventors the exclusive right to the respect writing and discoveries. And here the point, why limited time? Why don't we use like unlimited time? Do you know? Any of you have idea about like why we only protect the inventors or authors for a limited time, not unlimited time? First of all, we all agree that patent, if like the authors or inventors, they have patent, that means they have more motivation, both like a financial motivation and also image motivation to continue the work, to invent more technologies or useful artwork. But if we protect their work for unlimited time, so it's not really good, because if they can like they have monopoly. Okay, let me think about how to explain. Okay, so if they can hold the right to use that technology for unlimited time, that means no one else can use that technology, and then less application for like for society. So it's not good for the whole society in general. And they calculate that, okay, maybe previously, not now, but previously, about 20 years is like a right time to change from one technology to others, like the cycle, using cycle of a technology. That means the author and inventors, they can get much benefit during the first 20 years. So that's why they have exclusive right to their respective innovation in 20 years. And after that, other stakeholders, users can use it just to but just to pay for their application, but they are allowed to do so, because within the first 20 years, yes, without agreement from inventors, other partners, other stakeholders cannot use it. But after that, they can use as long as they pay fee as regulated. So that is like a big difference between like within first 20 years and after 20 years. So, but nowadays, the life cycle of one technology is certain. So now they are now discussing, okay, in how many years should an invention be protected? because now like even like after 1 year or 2 years, we new technology will be outdated immediately because very fast development in technology. So that's why always law have to be changed to adapt with new situation, new requirement from the society. So what is patentable? All like innovation can be patentable, but there are some not like unpatentable. So unpatentable subject matter, of course, we have whenever we have invention. When we talk about invention, that means we do not have any like reasons, scientific reasons like that before. And how about like and we can register for a patent. So we say like a patentable invention, innovation. And but for some reasons, for some like output, we cannot register for patent, like we say like unpatentable subject matter. So like law of nature. So we just discover law of nature. That means you cannot register for a patent because it happened by the nature. It's not like sometimes something you create or you think a new approach, a new method to um, to improve a process of a product. Okay, someone says I microphone is not good enough, and like okay, it's not loud enough. So it's I hope now it's okay. And also the second part is a physical phenomena. That means you discover some physical phenomena also like by nature. So you cannot register for a patent. And abstract ideas, that means you only have very brief ideas for even like a very great idea, new idea, but it's quite abstract. It's not full solution. So also you cannot register for a patent. And of course, it really the level of abstraction, it depends on each country. So in one country they accept this level, but in another country they are not. So it really depends on which country you want to register for the patent. And okay, so about this one, so you have to know that you in some countries they accept registration for a patent from other countries. That means, for example, you are doing research in Vietnam, but still you can register the patent for your research in USA, for example. So it's possible. And in that case, your invention will be protected at, at first in the country you register for a patent. The second one, if that country sign some like agreement or treaty, internet treaty uh, about like IP right protection. So if you are if you are invention protected by country A and country A sign the agreement with the country B, C, D, for example. So your patent will be protected in all countries relevant, like A, B, and C. And regarding to atomic weapons and also like a public domain, it's quite like varies from country to country as well. And also like regarded to the international law treaties, and then we have to verify it again whenever we want to register for a patent, either in our resident country or in other countries. And also with one invention, you also can register the patent for in different countries. Also, it depends on like do they have agreement or not, or they have what the system they use for patent registration. But nowadays, many countries they sign an international treaties that like okay, when a patent protected in one country, so it will be protected and regulated in almost other countries. So that will be like that will be very helpful for researchers and inventors. They do not need to spend time for registering patents like in all countries. It takes a lot of time, but still their patent are still protected. The question about IP is like who owns what, and it's quite complicated because of course when you achieve or when you invent an invention, that means you can like okay, it seems you are owner, but like okay, for the first part, inventors are owner, but unless there's a contractual agreement. And why? You cannot work alone. You have a team. You have need you need to use facilities for your research. You need money for your research. That means you have to sign a number of contracts, for example, labor contracts with university or research institutes or even company. And you also like have a contract or agreement with funders who sponsors. And in that contract or agreement, we should define very clearly if there's some like inventions created during the work. So who will be owners? Because for some university or organizations, they in the contract, labor contract, they state very clearly own results, own works, own like everything created during the working period. So the organization will be the owner. That means inventors are not owners. They just work for the organization and the organization will own everything. But in some cases, other case, they will have like a sharing agreement, like, okay, who will own how many percent and who will like, but remember that for IP right protection, we create conflict or we have conflict between inventors and other stakeholders like organization who employ them or sponsor who give them money. So we have to define the ownership very clearly. But the copyright, like the right, like the patent will belong to the inventor only who create that work. But for owner to make economic benefit, it's different story. So the patent will recognize or to confirm the inventors, but the owner of that invention will share the benefit, economic benefits. So inventors and authors. So you are an inventor of that invention if you made a creative contribution. You have contributed to at least one claim, and inventorship is well defined. And of course, in for each country, they will have different definition. And when you want to apply like a patent for a country, you have to find out like which country like which law or which definition they are using. But if you like, of course, when you can see in the scientific article or paper, you can see name of like many authors, co-authors. But for inventors, it's different. So in scientific paper, we can, or for invention, we can have like many authors. But for inventors, we have to limit in certain people who contribute like creative contribution, or who have like play an important role only. And in like, okay, order of authors in a scientific paper, we see like, okay, the first paper, the first author will be the most important people, the co-author and the corresponding author, and the author at the end will play less contribution. But order of inventors on a pattern carries no legend weight. That means we do not distinguish, okay, who is the first one, who is the second one. But like all inventors in one pattern play the same role. So that's why they have to clarify, okay, if you made a creative and important contribution, so you can be an inventor, otherwise no. Okay, so yeah, before going to the next content, so we will have a break of about 10 minutes. Yeah. Do you have any questions? If not, yeah, we can have a break.
Dạ. Định bóng này này. À đâu? Nó cái nào?
Licensing agreement. Why license? So ideas, innovations, and other expression of human creativity are converted into private property as like IP rights and protected by law through IP system. And so in that case, like when our ideas, innovation are protected, that means we have to create license for that. And because they are protected, but still they are tradable. So the licensing, the right granted by an owner. And that is important way to creating values with this asset. And when we have license, so we have like an income source and wider group of users and potential developers. So license is a paper, is a certificate paper to certify that, okay, this idea or innovation or technology or this creativity are protected and owned by an individual or by an organization. And then because they are tradable, so that means licensing agreement can help them to transfer the right to use or to own to other organization or individual. So for in licensing agreement, we have a licensor. That means this partner will give license to other partners called licensee. So the giver like of the license and the receive the taker of the license. So for example, one company cannot or does not want to be involved in the manufacture of product could benefit from licensing out technology by laying on the better manufacturing capacity, distribution, and outlet, local knowledge, and management, and other expertise of one or more partners. So one company, they own license of a technology, but they do not have enough capacity to produce the final product. So that's why they can get benefit from licensing out that technology to other partners who have enough capacity, enough local knowledge or management and other expertise for production the final product. And for licensee, so they do not have new technology, but they with the licensing agreement, they can have access to the technologies which are like already established or readily available for faster and for more efficient production process. So that means they can reach the market, the new market faster and with an innovative product and technology. And licensing, that means the licensor can have like can maintain the ownership of the IP into the technology and to have economic benefit. That means they still own that technology and they can have economic benefit at the same time. And for licensee, they do not have enough research to conduct its own research and development like R&D process. And so through licensing, they can have faster access to the technical advance that are necessary to provide new and superior products. So the same, more or less the same idea, like licensing out could help a company who own technology can commercialize its technology faster. Because if they keep only for themselves, so they cannot get any economic benefit, and not many others can know about that and can apply that technology. But if like licensing out technology can help them achieve that target. And of course, again, so licensee can have like opportunity to develop themselves, to enrich the current technology portfolio and create new product serve market opportunity. And licensing agreement can encourage the licensor do more technology transfer to others, because their benefit can remain and the ownership remain, and also like other companies know about them, and then they also have more funding to continue the research and the development of the technology. Of course, licensing also can have some disadvantage for both licensor and licensee. So licensor own investment can sometimes generate better profit than operating through a license agreement. So that means sometimes they can develop themselves and they can get better benefit from like their own application and investment in production, rather than like a transfer to another partner to do so, because other partners like a licensee, they do not have experience and also the capacity to understand and to fully exploit the new technology. So that's why sometimes they do not have enough, like they do not have better profit as the owner of the technology. And licensee may also like have made a financial commitment for a technology that's not ready to be commercially exploited, and that must be modified to meet the licenses business need. So that means the technology is not really ready but licensee still like have commitment, financial commitment already. So, it happens quite often in practice, because if you only like if you are licensee and you only buy license from ready technology, so that means it you will have more competitors, because when one technology is ready and is efficient, many other competitors, they want to buy that technology. It's not only you who want to buy. So that means at first you may not like able to get that technology. The second part is the price of the technology will be higher, because more competitiveness, that means licensor can increase the price. So often they will invest, or like you can see here, made a financial commitment for technology that's not ready. That means they will invest from the beginning of the research. So when researchers they present their proposal, okay, we will develop this technology to meet this requirement, this demand from the market, and then you see, okay, so it's quite potential research, and it may be very helpful for your business. So you decided to to invest in that research proposal. But sometimes the research cannot reach to the end as expected. Like, okay, they plan to complete the research during 2 years, but because of many reasons, both internal and external reasons, so research have to last until like 3 years, or even 4 or 5 years. So that means you expected to have ready technology by 2 years, but still now you have to wait for 4 or 3 or 5 years, because you already made financial commitment and you spent some money already. So you have to follow that direction, and so you lose your opportunity during the extended extended time, like 2 years in this case. And also like that one is also like a disadvantage of licensing. So here also you can see some other disadvantage of licensing. So for licensor, maybe licensee who buy license from licensors technology can be a competitor in the same market, because if they apply the same technology, so that means they will have the same market, the same customer profile, and then because they have like a more flexible For example, here, like some small company, they buy technology from big companies, and then because they are smaller and they are more flexible, they are more dynamic, so they can apply the new technology faster and more efficient. And then they will be a competitor, and they will have like a faster development in the same market. So it will harm to the licensor benefit. So that is like disadvantage of the licensor if they want to give license the technology's license to others. And for licensing, sometimes when they, of course, with the new technology, they can improve the quality of the product, of the service to the market. But sometimes when you use a new technology, it costs very expensive, but the quality increased or improved is not as expected. So here you can see like multiple technologies added to a product can result in a technology rich product that is too expensive to bring to the market. New technology, new product, but it's too expensive for the market, and then they will lose their market share and also like economic benefit. Here are some more disadvantage. So the licensor, a license agreement can be disadvantageous when the technology is not clearly defined or is not complete, and in such case, the licensor may be expected to continue development work at a great expense to certify the licensing. Okay, so let's see it. That means licensor can have license agreement with licensee in advance, as we said earlier. So at that time, the technology is not really ready, and the licensor say, thought, okay, now we need only 2 million US dollar in 2 months to complete the work, and then we can transfer on to the licensee. But suddenly they have they are facing some difficulties, and they have to spend 10 million US dollar during 1 year more to complete the function they expect to have. That means they may spend more money than the money they can get from licensing. So that is like one disadvantage of licensing. And in other way around, licensee may be like more rely or depend on the technology from other companies. So they are now become too technologically dependent, and it can be a barrier to the future expansion or the ability to adapt or to modify or improve the product for different market because they are like technologically dependent already. And for licensor, if they transfer, if they give license to licensee, that means they will depend on the skills, ability, resource of the licensee for generating profits. Because often in the licensing agreement, the benefit for licensor can be like a percentage of the benefit created by the licensee. So in that case, they can get only like a percentage of the benefit, and if licensee cannot generate any benefit, that means licensor will lose the money. So let's see a licensing agreement. So every license agreement is unique and reflecting a particular needs and expectation from licensor and licensee. And of course, in an agreement by licensee and licensor, we can have like many parts, like many requests from both parties, but still they have to follow the relevant laws and regulations as we said at the beginning. For example, they have to follow the technology transfer law. For example, here maybe like investment law as well, and or science and technology law or high technology law, depends on the nature of the technology they are now like doing license agreement. So that means the party of an agreement cannot raise something like impossible by the relevant laws and regulations. And let's take a look at the key contents that should be in the agreement. Yeah. So for subject matter, so subject matter is a license agreement may include the creation such as inventions, confidential information, or creativity expressed in novel plays, movies, music, name of goods or services, or business identifiers. And that is like the first main section of the license agreement, and it have an important influence on the content of agreement. So depends on the technology we are now talking about. So license agreement, like a subject matter of a license agreement can have different type. So it, for example, in the trademark license agreement, particular attention should be paid to the controlling the purpose of proper use of the trademark in advertising and marketing. and to maintaining the quality of the product or service bearing the trademark. So, or like for computer software, so some, for example, so application or some confid confidentiality will be maintained in the computer software. And to maintain the quality of the product or service, so trademark license permits the licensor to have access to samples and to inspect and the like. Because licensor need to make sure that, okay, using their trademark license, so own product or services have to remain the high quality as the regulation or agreement. Extent of rights. The second main sector of a license agreement related to the extent of the license right. So for this one, parties in the license agreement have to define the right very carefully. For example, in which area, in which geographical territory, for example. So sometimes companies just buy license in one specific province or country. So in that case, they have to follow strictly that agreement. So they cannot sell their product or service using that technology to other countries. So sometimes you can see here, you can see in the product, like, okay, this product is expected to sold in this like a specific country only. That means they are not allowed to sell in other countries because of license problem. It also related to not only like a geographic territory, but also like a time limit. So the license will be transferred in like 1 year or 2 years or like whatever time agreed in the agreement. Exclusive zone or non-exclusive. So a non-exclusive license where licensee is one of several licensees with whom the licensor has entered into agreement for the use and exploitation of the technology. And yeah, in that case, that means like the licensee is not only one buyer. There are several buyers using the same technology, and it also like get non-exclusive license. And in by giving non-exclusive license, so licensors that does not depend on the success of only one licensee. And for licensee, if they get non-exclusive license, they can have better price, they can pay less money for that technology. But this advantage here is like they have more competitors. If they do not strong enough, so they cannot sell product service with the same technology as other have, because maybe other competitors, other licensees, they have better capacity to transform technology to product or services, and then they can approach the market faster. So still, like, okay, depends on the capacity of each licensee. They will decide to buy or to go further with exclusive or non-exclusive. And of course, it also depends on the licensor. They want to have, like, to give exclusive or non-exclusive agreement or not. In other way around, so an exclusive license usually described a situation where the right granted to the licensee even include the right of the licensor in territory. And that means, like, the licensee is only one buyer of that technology. So in the same territory, only licensee and licensor can have that technology or can use that technology. No one else can use. And here is one example of exclusive license. So licensor grant to the licensee. Of course, you can see here in agreement, always we have one phrase like subject to the terms and conditions of this agreement. That means, like, they will have definition of terms and conditions, specific conditions for this agreement. It's not general conditions for other technologies, only in specific terms and conditions of the agreement. An exclusive worldwide license. So you see, worldwide, that means no limit by the territory of the use. And it is an exclusive license. And then licensee can manufacture, use, and sell licensed products for any and all use. Okay, so sometimes, of course, at the beginning, when the technology is new, so many licensee want to be like exclusive license. But after some years, maybe there are more technologies up here, and even the current technology is not used, it's not efficient enough. So licensee, they want only have exclusive license in few years, and then after that they will become like non-exclusive to reduce the cost. That means they just want to make use of that technology during first years only, and after that, like, okay, so more people and more similar technologies appear already. So it's not necessary to own that technology anymore in the term of exclusive license. And after the the time agreement, so and also like the same for territory, the license will be like non-exclusive, and from that moment, licensor can sell or can give another non-exclusive license to other licensees. In the case of non-exclusive license at the beginning, so both licensor and licensee can agree for non-exclusive license in each country of the licensed territory, because of course licensor can grant license to licensee in country they have license. Regarding to territory, the extent of the license can refer to the geographic territory, and of course, as we said, the extent can be regarding to time or to geographic territory. And for example, when one right could be granted, or the right could be for specific countries, or even like a specific province of a country or state of a country. So when licensee want to have like a license agreement for specific country or province, that means they see the most potential area to make benefit from that technology, because for one technology it can be very welcome in one country but not in other countries. So it really depends on like the licensee, how licensees evaluate the business potential for of each technology in each area. So let's take an example of like territory is Germany, and when they want to sell product to France, so they have to like, unless and until the licensor has granted a license in France, otherwise the licensee cannot sell the product or services to other countries. And in general speaking, in each case of a violation of this clause, licensee is obligated to pay three times the license fee to the licensor. That means licensor do not have license in a country, but licensee want to sell the product or service in that country without any agreement with licensor. So they have to pay more than like higher than license fee to the licensor. And when we talk about the European Union, that means now all countries in European Union, they have agreement to stating that, okay, one product sold in one country, that means it's allowed to sold in other countries in EU. So that's why like a visa problem for sanction area, if you get visa to one country in that area, in that region, so you can use that visa to travel to other countries in the same region without any new visa. Just so we can image the same thing for product. If you can get license to sell in one country in the EU, so that product can be sold and can be sold and used in other countries in the EU area. So that means whenever we want to sell or we want to apply to produce product in one licensed area, we have to verify that country or province have agreements with other countries around or any country in the world, that if we have license there, that means we have also license to other relevant countries. So it will save money and time to export new market. So we have license, non-exclusive and exclusive license, but still we also have a sub-license. And what is a sub-license? That means we have a general license for during a specific time, duration, and also like a particular territory, but still we have a sub-license with more conditions and or with more right in another specific territory, and it really and licensee have to negotiate with licensor, and own specific sub-license have to written in the agreement. let's take a look an example. So here, like licensee shall have the exclusive right under the license patents to grant sublicense to others, and then uh, and of course they want to have like because they have exclusive right already, so they want to use like to make use of that exclusive right to work with other partners to increase the capacity for product and service provide. And so in that case, they also have to mention the plan in the agreement in advance, and then it should be accepted by licensor in advance. And of course, in that, in most cases, licensee have to do cost and benefits analysis, because often with sub license, they have to give or to pay to licensor more money than like their own license. So they have to consider how they can get benefit from sub license and how their competitiveness level will increase or decrease with sub license. If they can get less than the increase in license fee to the licensor, so of course in that case they don't want to create the sub license, but they see they can pay, for example, 20% of their own revenue, but the sub license can provide them more benefit than that, so they may accept to pay more for sub license. Improvements in licensing agreement. So when dealing with improvement, also known as versions, like not only one version but several versions of agreement on enhancement or new models, it's important to define what is an improvement and therefore covered by the license, and what is a new technology or new IP related. So sometimes for one technology, licensors still develop it and improve it. So licensee both last year and this year technology is developed already. So in the agreement at the beginning, both are licensor and licensee have to state, okay, after 1 year or after one cycle of time, the, the technology will be updated, and then licensee can also benefit from those updates. So in that case, we have to modify or do modification to the license product, and it should be written and approved by licensor. And in other way around, all improvement of the licensed product shall be reported by licensee to the licensor, because when licensee buy license, they will produce some products or services, and of course during the production process they can improve, they can have some modification, they can have like add new values. So in that case, with own licensed product improved. So licensee have to inform or report to the licensor, and the licensor have participated in the improvement, and to make sure that all improvements to be named as joint inventors, and it will be written in an agreement, another agreement, or annex of the original agreement between licensee and licensor. The second case, change and improvements by licensor. Licensor shall inform the licensee of all improvements to the licensed product. This provision is applicable also for improvement for which patent application is filed. That means if the licensee and licensor have an agreement, the licensing agreement, every change, improvements, both by licensor or licensee, they have to inform to each other and get another agreement for those changes or improvements. Term, that means the duration of the license agreement can be influenced by the subject matter of the right being licensed. And for every licensing agreement, we have to define the term or the duration of the license, because after that duration, so no engagement between licensee and licensor anymore. And as example, you can see here, know-how or trademark agreement may be for 5 years, extended automatically for the same period unless one of the parties give prior written notice of the termination. And for other technology license like patent, copyright, trademark, so it depends on the market and the revenue estimation of the parties. So they estimate to have benefit only for the first few years, 5, 10, or 15 years. So they signed an agreement during that period only. So agreement for to the licensor by licensee for acquisition and or use of technology, often classified in two types. The first one is like lump sum, everything at once, or royalties. So you will have they will have to pay like for every month or for percentage of benefit or whatever, but it's not only like a lump sum. And then it should be written very carefully in the agreement, or many agreements contain both type of payment. It depends on the technology, on the specific conditions for each parties. Here is an example of the payment by royalty. So the licensee have to pay 5% on the net sales generated by the licensee. Is affiliates and sub-license or distributors in the field. That is one one type of payment. And I okay, so I think for this topic like licensing, you have to also like discuss in group, and also you have to prepare the midterm evaluation. So here you have to present like you can have a group of let's see how many of 3 to 5. You can work alone, but you can group 3 or 5 students work together, and you have to present a case of licensing, and you have to like okay, that case should be a very specific case like you see in Vietnam or in other countries. And then you have to of course you are not expected to have a long report, but you are expected to prepare slides to present a licensing agreement between parties, and then you have to point out the key contents of the licensing and explain the advantage and disadvantage of the licensing agreement you found as a case study. And do you have any questions about that assignment? And remember that case study will be the midterm evaluation. Do you have any questions about that? And no, I'm not sure that you have to present next week or the last lecture, because not me who will be responsible for the last 2 lectures. So Dr. Nam will continue the course with other contents. So I think okay. Of course, I will send you an email to explain the assignment. And for of course, you will have to prepare slides for your presentation. But do you need to present next week or the last lecture, or no, even like not presenting but only submitting slides? It really depends on the schedule, teaching schedule of Dr. Nam. So I will inform you like later whether you have to present or not. But anyway, you have to submit your slides. with the case study. And then I will give you more details of this assignments by email. So we will make sure that everyone have on the same page and I understand the same request. So is that clear? And do you have any other questions? So if you do not have any questions, so I will let you some time, some minutes to discuss to each other about the assignment. And then later on, maybe today or tomorrow, like this weekend, you will receive a clear information about the evaluation. And yeah, you can start the work quickly. Yes, and I will send slides this lecture and also like the lecture last week. So if you do not have any other questions, so I will close the lecture today now and see you later by email or even in other courses. Yeah. And if you if you do have any comments and any suggestions about the course, about myself, or any discussion you need to have, so feel free to contact me by email. Thank you.
Thank you, teacher.
Yeah.
Thank you, sir.
Bye, teacher.
Goodbye, teacher.
Good night,
Bye
teacher.
bye.
Thank you, sir.
Yeah.
Goodbye, teacher.